course. Oh. But introduction to yes. For today's lecture, we are having a very senior, most criminal lawyer practicing from Ahmednagar District Court, Advocate A.D. Chaudhari, who is having a very vast experience in the matters dealing in criminal as well as civil proceeding. He is also having a teaching experience of more than 25 years in our college itself. He used to teach during 2003 and 14 pattern in the our college criminal procedure code as well as company law. He teached. Even he teached to me company law and CRPC. So first I will introduce the nature of today's program to him so that he can get aware that what the program is. The program titled as Internship Program was prepared for fresh law graduate or those who are in the last year of their law course, so that they will get the knowledge of practical aspects of different provisions enumerated in different legislation. So today's topic is law relating to arrest under CRPC. Now this topic is important from the practical as well as academic purposes also, because for judicial service examination and recent advertisement of public prosecutions examination issued by MPSC, this topic is more important. Therefore, with this, I conclude the introduction of today's resource person and request him to deliver his lecture on arrest under Criminal Procedure Code. Yes, sir. Now up to you. You can start.
Thank you, sir. Good morning to everybody. Before I to go to our topic, I am wishing everybody of you Happy New Year. My topic is, as sir narrated, the arrest. If you see the Indian Constitution, you will find that every person has got a right to move throughout India. But this right can be restricted by the law, that is arrest. And now we have to know what is the meaning of person. Here in our jurisprudence, person means a mask owned by the actor. As the actor is wearing the mask, and as per the mask, he is performing his performance. And therefore, here the person includes male and female. Then we have to note that whatever the offenses we are having in our society, they have been described in our Indian Penal Code. Indian Penal Code gives the ingredient of every offense and also gives the minimum, maximum punishment and also the procedure. In order to try the Indian Penal Code cases, the Bible of our criminology is the Criminal Procedure Code. Criminal Procedure Code is a lengthy procedure, and here you will find it is covering almost all probabilities which may occur while trying the case. Now, we have to see what is the meaning of offense. Here, the offense means a act which is permanently prohibited by the law. This act, if you are breaking the breach of it, then you have to face the consequences in respect of which the punishment is there. Punishment may be jail or the punishment may be of fine. Now, with this, we have to go to our topic, and the topic is arrest. Arrest means to have the restriction to the movement of the accused. As we are aware, in our criminology, accused means a person against whom the charge for the purposes of committing the offense is there. Now, here we have to note, for the purposes of arrest, we will find the sections are there in our criminology from section 41 to 60. Along with this, we are also to concentrate on other sections, particularly 167, 258, and section 438 of the Criminal Procedure Code. Now, here you will find that the arrest can be done by the person, by the police, for the commission of any cognizable and non-bailable offense. There are two types of offenses in our criminology. First type of offense is a offense which is serious from the point of view of our society. And for in that category, we may include the dacoity, murder, rape, etc. There are also certain category of our offense which is requiring the less seriousness from the society point of view. And in that event, we can include the assault by the person by fist and blows. Or second one is one person is abusing the other person in filthy language. Those are the offenses which are styled as non-cognizable offense. Cognizable offense means a offense as regards to which the police can take the action without having any permission from the authority. Now, in this respect, if the person is committing the offense, then in that event, he can be arrested by the police. And for that purpose, we have to note that there are certain categories in which the person can be arrested by the police. For first, if the person that is accused has committed the cognizable offense. The second one is if the person person means police has got the information that this accused has committed the offense, and this information is the reasonable and credible information is there. Then in that event, that person can be arrested by the police. Then the third is if the person is having the suspicion from the police point of view. If suspicion is there, then that suspicion as regards to the commission of cognizable offense, then that person can be arrested. Then the further we may say, in the night, if the person is moving with the implements of house breaking, it means to say that this person is having the intention to commit the dacoity or the theft, and therefore he is carrying these instruments. Then in that event, that person can be arrested by the police. Then, as we are aware, if the person is having the commission of the cognizable offense and he is not traceable, then in that event, the government is having the power to proclaim that person as an offender. If the person is proclaimed as an offender, then the police can have the arrest of that proclaimed offender. Then the further category is if the person has committed theft and is having the stolen property in his possession, or the person has not committed the theft but having the possession of stolen property. And if that stolen property is there in the possession of the person, either in case of committing the theft by itself or having the possession of it, then the police officer can have the arrest of this person. Then we have to come to further category that the police officer is performing its duty and that person is obstructing that police officer while performing the duties, then that person can be arrested by the police. Then, as we are aware, that we are having the army, and in the army, various soldiers are there. And if the soldier has deserted his armed force and have come in the society, then that deserted offender can be also arrested by the police. And therefore, these are the reasons on which that person is having the arrest. And as we have to note, if that person has hello, if that person has committed non-cognizable offense, for our instance, if the person is passing with his bicycle on no entry road or having double seat, and the police officer is stopping him and asking his name, address, etc. If that person is deliberately giving a wrong address and name, then even though it is a non-cognizable offenses, that person can be arrested by the police for commission of a non-cognizable offense. Then we have to come to the another aspect of this arrest. The police is not the only person who can arrest the accused. There are other two categories of the person who can arrest the person. For the first instance, we may say the magistrate or any public servant who is having the witnessing that the person has committed the cognizable offense, then that person can be arrested by the magistrate. Or if the public is there, private person is there, and the private person is of the view that the person has committed the cognizable offense, then private person also can be arrested by the accused. And therefore, this private person is having the right to have the arrest of the person. Now we are going. What is the meaning of arrest? Arrest means to restrict the movement of the accused person. Then how it can be restricted? And for that purpose, the section is 46 of our criminology. Criminal Procedure Code says the arrest can be of by various ways. For our instance, that arrest can be effected by way of touching the body. The second one is that arrest can be having without touching the body, asking the accused to stop and to have the restriction to its liberty. Then in that event, the confinement can be there. Confinement itself is arrest. Then if the accused is to be arrested by the police and the person that is accused is resisting the arrest, then the police is having the power to use the adequate force for the purposes of the arrest. Here you will find that the accused can be arrested by the police, by the magistrate, by the public, any private person. Then we have to note, if the woman is to be arrested, then in that event, special provision is there in our criminal procedure code. Special provision is, if the woman is to be arrested in respect of cognizable offense, that woman cannot be arrested before the sunset and after the sunrise. And therefore, here you will find, before the sunrise, she cannot be arrested. After the sunset, the woman cannot be arrested. This is the special provision which is there in our criminal procedure code. Then we have to go that while arresting the accused, the police officer can search the accused. The search is as regards to the search is as regards to the some incriminating articles which are to be found on the person of the accused. If that search is there, and then in that event, the search is to be carried out by the police before the arrest. Then there are certain provisions as regards to the having the liberty which is restricted by the law. The accused can be having the right to know why for he is arrested. Therefore, the police officer is to give the grounds on which that accused has been arrested. And therefore, the grounds are to be there, which are to be reported by the police officer to the accused. Then here you will find, if the accused has committed the rape or he has committed the house trespassing and or he is having the equity, then in that event, the accused is also having a commission of the rape. If the rape is committed by the accused, then that rapist that is styled as accused can be arrested by the police. But while arresting the accused, the police officer, in case of rape, can send that accused for medical examination. And if the medical examination is carried out, then in that event, that person is having one more ground for the purposes of linking him with the crime. Then here you will find as we are aware, while arresting the accused, if the accused is resisting the arrest, then as I said to you, that the police can use the appropriate force. That is also styled in our common language as a third degree method. If third degree method is used, that is for the purposes of investigating the point. Investigating the crime, that third degree method is used. But that is to be used, as I said, in proportion. It cannot be exceeded. And if that is carried out by the police and that force is more than requirement, then we have to go to the criminal procedure furthermore, that after the arrest of the accused, it is a bounden duty of the police officer, as per our section 57, that to produce the accused before nearest magistrate. It is not necessary that the magistrate who is having the jurisdiction to try that case, to before him that accused is to be produced. This is not the law. Law says that he is to be produced before any magistrate within a period of 24 hours. Therefore, these 24 hours are to be counted, excluding the period for the journey. Now, this accused is having the production before the nearest magistrate. Then the nearest magistrate is having the power to have the question to the accused whether he is having any complaint as regards to the ill treatment at the hand of police. And if that ill treatment is a complaint by the accused, then that magistrate can send the accused to the medical officer. Medical officer examines and submits the medical certificate to the magistrate. And on the basis of that certificate, the magistrate is having a power to have the investigation as regards to the ill treatment given by the police. Therefore, this is the protection given to the accused, that to have the protection from the police excessive power. Then we have to go furthermore, that as we are aware, in our criminal procedure code, we are having two types of offenses. First offense is a bailable offense, and second one is a non-bailable offense. If the accused is committing bailable offense, then here we have to note that accused is having the right to get a bail from the police itself. It is not necessary that the accused should approach to the concerned magistrate. The police can grant the bail to the accused in case of a bailable offense. If the accused has committed the non-bailable offense, then here you will find the police is having no right to grant the bail to the accused. Then in that event, that accused who has committed the cognizable offense, non-bailable offenses, then that accused can be there before the magistrate. The magistrate can send that accused in two ways in the jail. First one is he can send the accused for the purposes of interrogation to the police, and that is known as police custody. If the police custody is granted to the accused, then we have to note that while in the police custody, the accused cannot claim the bail as a matter of right. And therefore, here you will find the magistrate is having the police custody to the accused as per the merits of the case. Now the question comes in our mind, how long the accused can be there in the police custody? The maximum period is given in our criminal procedure code, and the maximum period is 14 days. Whatever may be the seriousness of the offense, the accused can be granted maximum police custody, not more than 14 days. Then, after the expiry of the police custody, within a period of 1 day to the 14 days, the magistrate is having the power to grant the accused the magistrate custody. In the police custody, the accused is under the control of police for the purposes of interrogation. Now the question comes in our mind, why for this provision is there? This provision is there to have the detection of the crime. If the person is having the commission of a cognizable offense, and if the police is having the confidence in the mind of the accused, then the clue can be there for the purposes of having the investigation. And therefore, to have the clue, to come to the truth of the offense, the interrogation is necessary, and that interrogation is carried out by the police period of police custody of the accused. Then police custody is over. Then the magistrate can send the accused for the magisterial custody. If the accused is in the magisterial custody, then first thing we have to note that police have no control over the accused. The accused is sent to the jail under which the magistrate is having the supervision power. Now, we have to go furthermore. If the magistrate is granting the magisterial custody, police custody is over, then in that event, the person can approach to the bell and have the bell from the court. If the offense is to be tried by the magistrate, then the accused can prefer the bail application to the magistrate concerned. If that offense is to be tried by the sessions court, means more 7 years punishment is there as regards to the alleged offense, then that person can approach to the sessions court for the purposes of bail. Now, either magistrate or the session court, which is approached by the accused as per the law, the magistrate or the sessions court is not granting the bail as a matter of right. Now, we have to note that the magistrate or the session court is having the discretion, and that discretion is to be used judiciously, impartially. It means to say, as per the facts of the case, the court is having the power to have the bail to the accused or not to have the bail. Now, if the court grants the bail, then the accused is to furnish the bail and he is to remain present in the court as and when he is directed to be present in the court by the judge. That may be the magistrate, that may be the session judge. Now, if the magistrate is having the power, the magistrate is not granting the bail, then the sessions court is also not granting the bail on the basis of the gravity of the offense. The offense which is serious from the social point of view. And if the accused is to be released, then he is likely to tamper the evidence of the prosecution, or he is likely to abscond. Then in that event, the court is not granting the bail. Whether the bail is to be granted or not, this is the discretion of the judge, maybe magistrate, maybe the session judge. And if the discretion is to be used, as I said, again I am repeating, that discretion should be used by way of judicial. And on the basis of that judicial discretion, the court decides impartially whether the bail is to be granted or not. Now, we have to go furthermore. If the person is granted the bail, then the provisions which we have to look up henceforth may not be applicable. But as we are having the topic of arrest, if the bail is rejected by the court, right from the judicial magistrate, session judge, or to the highest authority of our judiciary, that is Supreme Court. Now, the accused in the jail in our cognizable case, then in that event, the question comes in our mind, how long he is to remain in the magistrate custody and at the mercy of the police as regards to the completion of the investigation. Now, in this respect, we have to note a special provision is made in our Criminal Procedure Code, and section is 167. That section says that the accused is in jail. Then in that event, if the police is having the allegation that the accused has committed the offense which is prescribing the punishment of death, life imprisonment, and last one is that punishment which the alleged is of the accused is more than 10 years. Then in that event, the police is to file the charge sheet within a period of 90 days. Then if the offense is not life imprisonment, death, or the offense is not prescribing the punishment more than 10 years, then in that event, the time limitation is 60 days. Within this period, the police is having the right to file the charge sheet. Now we go further. If the police not filing the charge sheet, either in the 60 days or 90 days, then in that event, the special protection is there in our Criminal Procedure Code. Whatever may be the nature of the offense that accused has committed. The accused is having the right to have the bail. Even though his bail is rejected previously, still the right is there, and the magistrate or the session judge can grant the bail to the accused, that accused which has denied the bail throughout the investigation. Then in that event, that is a new provision which is there in our criminal procedure code. Then we have to come that it is not necessary that the accused is to be arrested. Then in that event, if the accused is of view that he is likely to be arrested by the police, there is a reasonable apprehension in the mind of the accused that he is having the likely arrest by the police. Then in that event, what the right the accused is having? In that event, the accused is having the right to approach to the sessions court for the purposes of an anticipatory bail. This anticipatory bail provision is made to protect the liberty of the accused. And for that purpose, the section is 438 of the Criminal Procedure Code. That says that if the person is apprehending the arrest as regards to the non-bailable offense, then in that event, he can approach to the court, that is sessions court, for the purposes of bail. And that court is having again the discretion to grant the bail or not. And this discretion, as we have observed, is to be used judicially impartial. Then the court is having the case before it. Court is hearing the defense counsel as well as the prosecution. And if the court finds that in order to cause the injury to that person, this case is likely to be filed or has been filed, then the court is granting the bail. Then in that event, here we have to note the police cannot arrest the accused, and without the arrest, the police has to complete the investigation and file the charge sheet. Now in that event, if the 438 section is used by the accused and the accused is filing an anticipatory bail to the court, then the court is to grant the bail or to reject the bail after hearing the arguments. The court is having giving the opportunity to the prosecution for the purposes of submitting its say. And after submitting the say by the prosecution, the court is hearing the arguments of the both sides, that is the defense counsel and the prosecutor, and thereafter the court rejects or grants the bail. This is having the time-consuming procedure. Then in between prime, if the court finds that this is a fit case where the ad interim bail is to be granted, then the court grants ad interim bail. Ad interim bail means that bail which is to be continued after filing of the application till the decision of the court in case of an anticipatory bail. That is a provision which is made by the law in our criminal procedure code. And therefore, here you will find that provision is there as regards to the cognizable case, and the person is having right to approach to the court if his liberty is likely to be curtailed by the police or by the complainant arbitrarily, because of the vengeance, because of the enmity, because of the political rivalry, that person is likely to be roped in that case, and therefore which is having a injury to that person. Therefore, this is there for the purposes of the Then the last is that while deciding an anticipatory bail application, the court is having the discretion again, and that discretion is the court may compel the accused to appear before the court at the time of hearing. Personal attendance can be directed by the court, and this is a discretion of the court. The court may grant, the court may not grant. And therefore, here you will find that a person may come with the advocate and have the representation. It is not necessary in that case that he should remain personally present in the court. But if it is directed, then even though the defense counsel is there to represent him, still the accused is to remain present in that court. And now the last one is, if the direction is given by the court and the accused is not appearing in the court, then in that event, the court is having the power in twofold ways. The first, court can adjourn the hearing of the application, and the court can direct the defense counsel to ask the accused to remain present in the court. Then, even though adequate opportunity is given, the accused is not appearing, is not remaining present in the court, irrespective of the direction, then in that event, the court is having the direction, the court is having the right to reject the application. Therefore, these are the various reasons, these are the various ways by which the person can be arrested and are having the provisions as regards to the bail. Now, here we have to note that the punishment is there. That punishment can be of two types. The punishment can be jail sentence, may be of imprisonment, depending upon the nature of the offense. And here you will find that ingredients are there in the IPC code, and the procedure is given. The minimum, maximum punishment either in jail or conviction, jail sentence, or the fine, minimum, maximum, is prescribed in our criminal procedure, in our Indian Penal Code. And therefore, here we have to note that the Indian Penal Code is the guideline for the purposes of the trying the criminal offense. Then how it is to be tried? And that is to be tried by the help of a criminal procedure code. And criminal procedure code is a lengthy procedure. Here we have not to scratch our head for the purposes of how to conduct the trial, or what would be the problem if it is there while conducting the case, then what we should do. And for that purpose, all the probabilities which are there, which are likely to come in trying the offense, have been considered by our legislators, and they have made the adequate provisions in Criminal Procedure Code. Criminal Procedure Code is comprehensive. This provision is, this Criminal Procedure Code is taking into consideration all the probabilities which are likely to be there while conducting the offense, while having the arrest of the person. And therefore, Criminal Procedure Code is encyclopedia of our criminology. Then the last point which I have to raise, in respect of a non-cognizable case, as I have said, this is may be there by way of the summons case, warrant case. Then in that event, as we have already noted, that the police is having the right to grant the bail. Now we are coming to the summons case. If that case is to be tried by the court, and if that court is trying the summons case, as we are aware, the summons case means the maximum punishment is 2 years. Then in that event, as per our section 258, here we have to note, if the prosecution is delaying the conducting of the case, if the prosecution is not asking the complainant or the witnesses to remain present and to give their evidence, then in that event, the magistrate is to have the reasonable opportunity to the prosecution. And if that complainant prosecution is not having the reasonable opportunity use and they are delaying the lingering of the case, then in that event, the section 258 is there. Here it says that the magistrate is having the power to stop the proceeding. And this can be there in exceptional case. It is not the right of the accused, but it is to protect the liberty of the accused. In this is there only when the magistrate finds that deliberate lingering of the case is there by the complainant, by the prosecution. Then in that event, that case can be stopped and the accused, if the charge is framed in someone's case, can acquit the accused, or if the charge is not framed, then the court can discharge the accused. And therefore, these are the various provisions which are there in our criminal procedure code as regards to the arrest and as regards to the further to protect the right of the accused. Now, I am having the end of this topic. Now, if you are having any doubts as regards to the topic which I taught to you, then you can raise the questions to me.
Yes, if you have any queries, you can ask. Students.
I am not hearing you. What is your question? I am not hearing you.
नाही सर, मीच विद्यार्थ्यांना विचारतोय. तुम्हाला काही क्वेरी असतील तर विचारा.
हो.
हां. तुम्ही मेसेज मध्ये टाइप करू शकता. मी मेसेज वाचून सरांना सांगू शकतो. येस. काही क्वेरी नाहीये का? येस, एक आलाय सर प्रश्न.
हो, सांगा ना.
ज्वेनाईलच्या बाबतीत आहे.
कशाच्या?
ज्वेनाईल्स.
हा, ज्वेनाईल. सांगा.
How juvenile can be dealt with from the case if he is intentionally involved in particular crime?
काय काय परत सांगा.
ज्वेनाईलने जर स्वतःहून एखादं क्राईम केलं असेल म्हणजे इंटेन्शनली, तर हाऊ पोलीस कॅन डील विथ सच केस?
All right, I follow.
Yes.
Now I follow. Now your question is, now your question is, if the accused is a juvenile,
Yes.
and if he has committed either bailable or non-bailable, cognizable or non-cognizable, then what is the procedure that you want to know from me? Correct?
Yes, sir.
Then in that event, we have to note if the juvenile is there, then for the purposes of juvenile offender, there is a separate law which is known as Juvenile Justice Act. And the Juvenile Justice Act is prescribing the age for the commission of the crime. If the person has committed any offense, cognizable and non-bailable offense, and that accused is below the age of 18 years, then he's a case, he cannot be arrested. Then that provision is a separate, and in that event, separate court is there, and that court is known as a juvenile justice court. And this court is not only one person, but here that court is also having to help while delivering the justice to other members. And these two other members are appointed by the government. And anybody cannot be appointed as a member. Then who can appoint a person who is having the social duty, social sense? That person who has done social work, then that person who is knowing the psychology of the child, that person's male or female is appointed along with the judge, and that judge is trying the juvenile offender. That accused is not the word which is used in the Juvenile Justice Act. The word is delinquent, and that delinquent, even if the court comes after the hearing of the case that he has committed the crime, then in that event, that person cannot be given the conviction. He is given the opportunity to improve in future. He is having the bond from the parents, and he is to give the guarantee to the court that he will have the peaceful life and will not commit any crime, whatever that period is prescribed by the court. And the court is granting at the most 2 years bond to the juvenile. And even if the person, that is juvenile delinquent, entering into the bond, the court finds he is having the commission of the crime, then it is not a stumbling block to its career. That person can have, without that punishment, a easy life, free life in the society. And furthermore, the proceeding of the juvenile court, that is the delinquent, trying the delinquent who is having the commission of the crime, this proceeding cannot be published by any person, and therefore the protection is given to the delinquent. Then here you will find another provision is that whatever the reasoning which is given by the court is having the power either to convict the delinquent and to ask him to have the execution of 2 years of good behavior bond from the parents, or can acquit the accused. Then in that event, whatever the order that is called in our criminology judgment, if it is there, then that judgment cannot be obtained by anybody. Here you will find protection is given to that delinquent. The judgment is not having the copy. The certified copy we cannot have of that trial. And therefore, this is a peculiar provision which is made to the juvenile. And this juvenile court, juvenile delinquent is tried not by in our regular court, but the premises are different. The juvenile should not feel that he is in the company of a regular offender. And therefore, here you will find the place is also different. And as I said, again, I am repeating that the delinquent is not having any blot after the execution of the bond also. This is the question. This is the answer of your question. Is there any other question?
गुड मॉर्निंग सर.
सर,
सेशन कोर्टामध्ये किती वेळा जामीन नाकारला तर आपण हायकोर्टात त्याला पुन्हा जामिनासाठी अर्ज करू शकतो?
नाही, त्याचा असं आहे, यू कॅन हॅव bail application as many times as you are wishing. There is no restriction as regards to representing bail application. But the court may reject the bail application repeatedly filed if no fresh grounds are there or no change circumstances are there. If the change circumstances are there in your case, then you can file the bail application in the very court or even to the High Court. High Court, you can file the application against the judgment of the Sessions Court. There is no restriction. More?
Hello, sir.
कस्टोडियल साठी कंप्लेंट कशी करता येईल सर? व्हॉट इज द प्रोसेस?
मला आवाज ऐकू नाही आला.
सर कस्टोडियल डेथ साठी कशी कंप्लेंट फाईल करता येते? व्हॉट इज द प्रोसेस टू फाईल कंप्लेंट फॉर कस्टोडियल डेथ?
कस्टोडियन डेथला मी तुम्हाला सांगितलं, कस्टोडियन डेथ म्हणजे तो पोलीसच्या कस्टडीमध्ये असताना पोलिसने 3rd डिग्री त्याच्यावर जास्त वापर केला आणि त्याच्यात तो मेला. तो जो मेला नंतर त्याची जी इन्क्वायरी आहे त्याची इन्क्वायरी होते. जो मेल्यानंतर पहिल्यांदा त्याचं पोस्टमार्टम होतं आणि पोस्टमार्टम शिवाय त्याचं इन्क्रिमिनेशन, त्याचं डेथ होत, त्याचं लास्ट स्पिरिच्युअल व्हॅल्यू होत नाही. तर त्याला पहिल्यांदा डेथचं असेल तर पहिल्यांदाचं पोस्टमार्टम होतं. पोस्टमार्टम म्हणजे काय? पोस्टमार्टम म्हणजे त्याच्या अंगावर काय काय इंजुरीज आहेत हे तो मेडिकल ऑफिसर त्यामध्ये नोट करतो आणि त्या पाठवतो. आणि त्या इंजुरी ज्या आहेत त्या इंजुरी जर त्याला असं वाटलं की ह्या इंजुरीज मुळे तो अक्यूज मेला तर ते सर्टिफिकेट येतं आणि कोर्टाच्या पुढे आल्यानंतर मग कोर्ट आपणहून त्याच्यामध्ये ऍक्शन घेऊ शकतं किंवा त्या पोलीस ऑफिसरचे वरचे जे पोलीस ऑफिसर आहेत ते ऑफिसर त्या पोलीसच्या विरुद्ध खटला दाखल करू शकतात. असे अनेक आपल्याकडे खटले झालेले आहेत की ज्याच्यामध्ये एक्सेसिव्ह फोर्स पोलिसने वापरलाय आणि कस्टोडियन डेथ झालेला आहे. आणि कस्टोडियन डेथ जर झाला तर मग त्या पोलीस ऑफिसरला प्रोटेक्शन नाही. त्या पोलीस ऑफिसरला आपल्या रेग्युलर ट्रायल सारखंच वापरलं जातं, प्रोसिजर फॉलो केलं जातं आणि त्याला काय जे मेरिट्स प्रमाणे शिक्षा होते किंवा तो सुटतो.
हॅलो सर.
ओके,
नमस्ते, गुड मॉर्निंग.
गुड मॉर्निंग.
हा माझा प्रश्न असा आहे की समजा एखाद्या माणसाला पर्सनला आर्म्ड ऍक्ट लावलाय.
काय?
आर्म्ड ऍक्ट. हा, तर त्याच्यासोबत त्यांचा मुलगा आहे समजा, नाही का? तर पोलिसांनी त्या ह्याच्यामध्ये ना अपोजिटने जेव्हा फिर्याद दिली, FIR दिला, तेव्हा त्या मुलाचं नाव नव्हतं सांगितलं पण त्यांनी ते नाव घेतलं, तर मग काय करता येईल? म्हणजे कुठे ऍप्लिकेशन काय करावं लागेल?
नाही, काय होतं आता तुमच्या प्रश्नामध्ये तो लहान मुलाचं वय किती याच्यावर अवलंबून आहे.
14 वर्ष.
तो काय, मग त्याची केस सेपरेट केली जाते. समजा त्यांनी जर ऑफेन्स केला असेल तर तो ज्युनाईल जस्टिस ऍक्ट प्रमाणे
नाही सर, ऑफेन्स केला नाही, फक्त सोबत होता तो त्या वडिलांच्या.
मग त्याला बाजूला केलं जाईल ना. मग जो वडील जे आहेत की वडील किंवा आई त्यांना त्याच्यामध्ये इन्व्हॉल्व केलं जाईल, त्या मुलाला बाजूला केलं जाईल.
म्हणजे कसं करता येईल सर
बाजूला कसं? म्हणजे पोलीस काहीच करणार नाही. पोलीस आईला किंवा वडिलाला अटक करतील आणि ते मुलाला सांभाळायला त्याचे घरातले जे कोणी नातेवाईक असतील त्यांच्या ताब्यात देतील. आणि समजा
त्याने काय केलंय, पोलिसांनी जाणून बुजून त्या मुलाचं नाव टाकलं, तो सोबत होता म्हणून.
नाही, नुसता सोबत असल्यामुळे त्याच्यावरचा गुन्हा होत नाही. त्यांनी काय गुन्हा केला, त्यांनी काय ऍक्ट केलेले, म्हणजे त्याला आमच्या क्रिमिनल भाषेमध्ये ओव्हरटॅक काय केली आणि जर समजा ओव्हरटॅक केली असेल तर त्याला घेतला जाईल, नसेल तर त्याला सोडलं जातं.
त्यानं काही नाही केलेलं पण त्याला सोबत घेतलाय त्यात.
आणि समजा त्याला जर घ्यायला कोणी कस्टडी घ्यायला कोणी नसले तर त्याला जिथं आपल्या संस्था आहेत त्या संस्थेमध्ये पाठवलं जातं की जिथं लहान निराश्रित लोकांना सांभाळलं जातं तिथं पाठवलं जातं.
मला लक्षात आलं ते, पण तो गुन्हेगार नसताना त्याला गुन्हेगार म्हणून पोलिसांनी त्यात टाकलेला आहे.
मॅडम, त्याला ते कोर्टासमोर सिद्ध करावं लागेल आणि त्या मुलाला त्या प्रोसेस मधून जावं लागेल. ज्यावेळी कोर्टासमोर सिद्ध होईल की त्याची इन्व्हॉल्वमेंट नाहीये त्यावेळी तो रिलीज होईल. त्याला ज्युडिशियल कोर्ट समोर नेलं जाईल तिथं
ओके
ते तिथं वकील सांगतील की त्याचं नाव घेतलेलं आहे, बळच त्याच्यावर काही पुरावा नाही, काही नाही. थोडक्यात त्याला त्या प्रोसेस मधून जावं लागेल. आता पोलिसांनी त्याचं नाव घेतलं म्हटलं.
ओके, थँक्यू सर, धन्यवाद.
आणखीन काय प्रश्न आहे?
हॅलो सर.
हा बोला. गुड मॉर्निंग.
गुड मॉर्निंग सर. सर माझा प्रश्न असा होता, मोका केस मध्ये जामीन कसा मंजूर करता येईल?
कशात?
मोका केस आहे, त्या प्रोसिजर मधून
नाही, मोका केस मध्ये जामिनाची प्रोव्हिजन नाहीये.
ओके सर, म्हणजे जामीन नाही होऊ शकत का त्यात?
नाही, मोका मध्ये जामीन नाही.
ओके सर, थँक्यू सर.
आणि मोका म्हणजे हार्ड क्रिमिनललाच लावला जातो, हॅबिच्युअल ऑफेंडरला.
ओके सर.
एनी मोर क्वेश्चन्स?
येस, ठीक आहे. मला वाटतं आता काही क्वेरी नाहीयेत. आपण इथं थांबावं. कुणाची असेल तर विचारा, नाही तर मग आपण इथे कन्क्लूड करू लेक्चर. ठीक आहे सर. कुणाच्या काही क्वेरी नाहीयेत. ज्या काही क्वेरी होत्या त्या आपण सॅटिस्फाय केल्यात.
बरं.
इथे आपण थांबू. त्याआधी मी सरांचे महाविद्यालयाच्या वतीने आणि संस्थेच्या वतीने आभार मानतो.
आय एम व्हेरी मच थँकफुल फॉर द पेशंट. Thank you very much for the patient hearing and giving me the opportunity to be with my students. Thank you.
Yes, thank you very much, sir.
Thank you, sir.
Hello, sir. 5 minutes.
जमलं का सर? Yes.